Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? Let me introduce you to our panelists today. We have Nia Johnson, who's a visiting assistant professor of law at Duke Law School. We have Bettina Krause, who is the editor of Liberty Magazine. We have Ms. Jennifer Woods, who's the General Counsel and Director of Public Affairs and Religious Liberty for the Lake Union Conference of the Seventh-day Adventist Church. And we have Mr. Vilo Weiss, who's the Director of Public Affairs and Religious Liberty for the Indiana Conference of the Seventh-day Adventist Church. Great to have you guys here with us and looking forward to our conversation today. You know, we've seen a lot of things that's been going on as it relates to the questions of the reversal of Roe v. Wade. The Dobbs case that actually was recently decided has now done away with what we've seen as it relates to activities, as it relates to terminating births. However, we are starting to see that the Supreme Court, after their decision, has pushed some of the other branches of government to getting involved. You're starting to see that the executive office is putting in place some executive orders. Congress is talking about putting in place some other things. And part of the executive order that Joe Biden has placed to us is put in place that you can do away with, quote unquote, engaging in conversion procedures, that there can be safeguards from health care and programs designed to prevent youth suicide. There's also been some support as it relates to preventing homelessness and improving access to federal programs. You know, one of the things that we're seeing here, Bettina, is wondering what's going on, but how are we seeing that we are looking at legislative bodies that are beginning to engage in activities to try to combat some of the things that's been happening in Supreme Court decisions?
Right. And I think that is a natural reaction of the different branches of government to any sort of landmark decision that changes the legal landscape, that changes the status quo. And, you know, you can debate one side or the other, whether executive orders such as this are legally justified, whether they can be defended in the courts, and that will be an ongoing conversation. But, you know, the executive order that you referenced, Orlin, which dealt specifically with LGBTQ individuals and the risks they face in society, you know, when we look at that, I think we have to take as our threshold issue, at least for me, that there are real harms that exist. There are real dangers that exist to this community. It is a more vulnerable community in society. LGBTQ youth are more than 50% more likely to consider or attempt suicide. Homelessness rates among that community are very, very high. So as we frame this conversation, I think that needs to be our understanding and the point that we sort of leap off from.
You know, Jennifer, when you take a look at what the president is trying to do with these categories here, you know, and the idea that this may find itself before some court system, have they gone through the process in the way that makes sense? And executive orders, how often do they find themselves really accomplishing what their original goals are?
I mean, I think that this goes back to what Bettina said. We're going to find out. There will be challenges. And so we'll see if you know, this administration went too far, if they struck the right balance as far as what the direction that they took and what kind of protections that they're trying to further through regulations and other things. But as we see, you know, this is really a response to how some Republican-controlled states, at least from what the White House has said, they're trying to combat some of the discriminatory legislation that Republican-controlled states have already put in place by issuing this executive order. So again, we'll see, has he overstepped his bounds or not? And while I do think that Bettina's right, that all people should be treated with respect and with dignity, and that these groups in particular are vulnerable and have real harms that they're experiencing. I think that what we also need to talk about is the balance between addressing the harms to this community, which are real, while also protecting people of faith and organizations, faith-based organizations, to continue to practice in a way that is consistent with their beliefs and teachings.
You know, Nia, it seems like if you look down the middle of some of this information, that the focal point of being on really safeguarding from a healthcare perspective or programs that are designed to prevent youth suicide would be the types of things that it'd be difficult for any side to really push against. And it seems as though maybe that will be the aspect of it that you kind of take the lead on as opposed to some of the other parts of it. I mean, from your perspective, what are you thinking?
I mean, I think Jennifer makes a really great point about, like there does need to be a conversation about checks and balances. But I think what's not being said, and I think it's because it makes us uncomfortable, especially for those of us who, engage in the law, is that we don't really want to admit that Congress has actually become relatively ineffectual. And so the reality is that the executive branch is taking steps to protect citizens of this country from many things that are, very barbaric. Like, I don't think many of us are aware of how conversion therapy actually works. And in many times, it's really a form of like self-flagellation, some level of like pain to an individual, to suppress what some, denominations, some groups may consider to be immoral sexual urges, right? So there are people who are actually harming themselves, trying to be in some level of alignment with their faith systems. And that has to be addressed. And that is also problematic. And so when we don't see Congress actually moving forward and acknowledging people and as individuals with dignity, then you're forcing the executive branch to act. And so I think this actually provides a larger conversation about why are our state legislatures, why are our federal legislatures not doing what they are supposed to do so that the executive branch does not feel compelled to act in this way.
Vilo, is actually this idea of ineffective activities happening from a legislative standpoint seems to be what's throwing the whole checks and balance system out of the way. We've got courts that feel like they've got to make decisions to really kind of create the law. We now have the executive bodies looking to think that they need to create the law because of that quote unquote ineffectiveness that's taking place. Where does the population or where does the citizenry start pushing back to say, hey, let's everybody start doing their jobs so that we can really kind of have the right checks and balances?
I hope that happens, Orlin, because Congress has punted on a lot of things here, and we see the Supreme Court legislating from the bench, particularly in Boston. It's up to Congress to expand the protections for the LGBTQ community, which they have in the Equality Act. And I don't have a problem with the executive orders when they facilitate carrying out the law, which is the president's job under the Constitution. But I'm troubled when it starts making law as well. We're running roughshod over separation of powers.
Bettina, that's a great point that Vilo is raising, that the executive orders are really supposed to be coming in and supporting laws in a way that, would make it more effective. But this is pretty clear that this is a law that or an order that's trying to come in and actually go against something that came down from the Supreme Court. How do we juxtapose that to ensure that this executive order actually has validity?
And you're making a great point here, because the purpose of Congress ostensibly is to provide a venue for civil discussion about sort of give and take that's needed to live in a pluralistic society such as ours. And as has been pointed out, that function isn't really happening at present. And so, yes, you see one branch of government asserting a right to put forward a point of view or a perspective which many will see as unbalanced or as in pushing a certain ideology. And these issues that we're talking about today they're so complex from so many different perspectives that we need the sort of reasoned conversation and dialogue to really engage with them. Take just the issue of conversion therapy. Yes, it is utterly barbaric in so many circumstances and forms. Yet there are some who would also include prayer with a supportive prayer with an individual who's struggling with their sexual identity. They would class that as coming under the head of conversion therapy. I don't think so. We need that sort of nuanced discussion that an executive order does not lend itself to. We need that discussion to really make headway with a topic such as this.
You know, Jennifer, what's interesting is it looks like even where the courts are going, they wanted to punt a lot of this back into state legislatures. You know, the federal government and the Congress looks like, well, let's stay away from this. Let's put it in the state legislature. But when we see that happen, what are some of the downfalls of that?
I mean, to me, the downfall is that depending on where you are, it's inconsistent rights. And when we're dealing with vulnerable populations, I do think that the federal government has a role to play there in protecting all people, all citizens and all residents here, and anyone who's here in the States. And, we talk about, Nia talked about how Congress is being ineffectual, but when we look at the state level, the legislative branch is very active. And it would be nice if we saw that same thing happening on the federal level, again, so that we had some consistency as far as some basic rights for people dealing with dignity and respect for all individuals.
You know, Nia, you're down there training students in law school, and I would imagine, there was a lot of thought that laws would really be kind of focal point from the federal standpoint. But as Jennifer is mentioning, we're seeing a lot more activity at the state level. Are you finding more conversation going on, in law schools with students talking about how we can make impact at the state levels, because that looks like there where much of the action is?
Well, I don't think there's as much credit given to state legislatures, and that's something I do try to encourage my students to do. I mean, this was something I learned firsthand while working for the Massachusetts Health Policy Commission. And, there is a lot that can happen in the venue of the states. That's how you can end up with a state like Massachusetts that, laid the foundation with, what many people forget was Romney Care, right? For providing some level of universal coverage and transitioning that into the Affordable Care Act that we see today. And so I think states have a lot of work to do in that area. But I also think it's important to acknowledge that there is this inconsistency of rights that we see across the states, and differences in opinion are not the same as protecting rights. There seems to be this idea lately that, oh, well, it's just my opinion that certain people should not have the same access to certain things. It's like, well, no, these are rights, and there are reasons why we allow for individuals to share in the polity and share in practical citizenship. And sadly, our state legislatures do have a history of, denying that for many groups of, minority individuals. We saw this during the civil rights movement, and we are seeing that to some extent now. And I think that's something we have to be equally as mindful of.
Vilo, one of the things I think we're starting to see is there's better understanding at some of the real impact that's impacting the LGBTQ plus community. And we, as people of faith, always want to make sure that we're protecting our interests. But I think there's a sensitivity that I think we're starting to see where we understand, listen, we want ourselves to be protected. However, we don't want to see another group put upon simply because we're not on the same level. Are you starting to see more of that, or even more of that dialogue starting to take place from a church perspective?
Yeah, I hope so. We saw that in Utah with the LDS church there, Church of Jesus Christ of Latter-day Saints, and the Utah Compromise. And we have to, particularly as Christians, Jesus calls us to be light and yeast and salt, and we need to have a positive impact on our culture. And my wife and I, we have a number of friends in that community. And we do that purposely. We want to be an expression of God's grace.
Well, I'm going to give you the last word on that, Vilo, but I think that is the point that we all should be thinking about. There's a way for us to peacefully live amongst each other and to make sure that all rights are protected without putting upon for somebody else. I'd like to talk about a case that came out not too long ago. It's a case that's called Braidwood Management Inc. versus Becerra. It's an interesting court case that took place down in Texas, where we started to see some headlines that were being made because there was an argument for a nonprofit business that it had the right to deny employees insurance coverage for some pre-exposure activities. Now, one of the things that I find interesting about this case is that we started to see decisions along this line taking place at the federal level, but because everything is a case-by-case basis and a fact-by-fact basis, that we're starting to see another nuance of this is happening happening down in Texas. Nia, I want to get your thoughts on the idea when you have an employer that's basically saying that there's a substantial burden and that they have a religious belief as to why they wouldn't want to engage in certain aspect of providing insurance that the government may say is required. How do we juxtapose that against protecting somebody from their religious beliefs as opposed to finding that fine line of not discriminating?
Well, I think we have to start with a little bit of knowledge. And that's why I love these types of questions, because one thing that seems to plague many religious communities, not just Christian, but, the broader Judeo-Christian, spectrum of religions, is this idea that it would never be me. And so therefore, we don't need to provide this service. And then on top of that, by not providing this service, we are doing some level of conversion, right? We are doing some level of bringing people into the fold by leading with our example. And I think the really harsh reality that many, religious institutions are starting to see, we've even seen this in some religious institutions and colleges as well, is that we actually aren't that different from other people. And it's important to think about, when we talk about drugs like PrEP, it's not just queer individuals who use PrEP, right? Like it's also like individuals who have been infected by HIV/AIDS from other circumstances. Children also can have HIV/AIDS as well. And so this idea that it would never be you, it may not necessarily translate. We also have seen this in debates around abortion where, we're like, well, I would never have an abortion. It wouldn't be me. I'm a married person. I have sex in a quote unquote moral way. But we also know that 1 in 4 pregnant persons in the United States have had an abortion. And that has to translate inside the walls of the church. And so I think we need to be a little bit more tapped into, our spiritual bodies, and then also a little bit more honest in our homes about who needs these drugs and when, and why we are just so, unwilling to provide people with opportunities that we may actually need in the future if we were really being transparent.
Bettina, did they go too far in Texas? I mean, the idea of trying to say that this was a substantial burden, and it seemed as though they tacked it into a religious conversation. But as Nia's mentioning, there could be a lot of people that may be using this that has nothing to do with what may be violating their religious beliefs. Where did they kind of, veer into this conversation? And should they probably find themselves being stared back in some form or fashion?
Right. So the plaintiffs in this case are claiming that these pre-exposure prophylactics such as PrEP will actually encourage homosexual behavior or sexual behavior which is in accordance with their own moral code. And so then being forced to provide that is the burden that they cite. Now, you can look at this a number of ways, but let's just take the standard compelling state interest test that is so often applied in these cases. Okay, so let's take these people's word that they feel that their religious beliefs or convictions are being substantially burdened. I think there is a case to be made that there is a compelling government interest to mandate the coverage of this particular drug simply because, number one, it is 99% effective. It does save lives. Second, if an individual has to pay out of his own or her own pocket, it's $21,000 a year, which is prohibitive. And so looking at it strictly through a legal prism, I think that weighing process, which we always have to go through when we're talking about religious freedom rights as opposed to other rights in the community, this weighing process needs to take place. And frankly, in this instance, I would be loath to deprive individuals of a drug which could save lives.
Viola, this weighing process that Bettina is talking about, that compelling state interest, which always seems to be one of the crux of what we look for when we're trying to figure out how do we find the right balance. Where do we find ourselves with these arguments where you can actually have an entity or an organization, which in and of itself is a little bit questionable, where they used to have these rights of protected persons, but now are protecting entities. Where do we find the balance here? Or is the balance in line and we're just missing it in this conversation?
Well, we've already been down this road with Hobby Lobby, which was a consolidated case. You had Hobby Lobby, which is all over the place. You have Mardell, which is owned also by the Green family, basically located in Oklahoma, and then you have Conestoga Wood Specialties. and in that case, they were opposed to the abortifacients under the Affordable Care Act, and so we've already gone down that road with the for-profit. That's been a little bit troubling to me. I would feel better about that in terms of the church, but the court's already gone that way on for-profit, so I'm not sure they should have gone that way.
Well, Jennifer, when we look at this particular case here, we start to find out that there are some real specifics where it looks like organizations now are in the process of telling you what, quote unquote, is that right balance. And depending on what forum you're in, from a court perspective, you win or you lose. And it seems like this probably is something where we do need potentially the federal level to come in and try to straighten all of this out. Or am I missing something here?
No, I agree. I think that, again, this is why where the federal government and federal legislation really does play a part. So we don't have these inconsistent rights depending on which state you're in or which jurisdiction you're in. And I think, what struck me is going back to something that Nia said, and this is that this isn't just impacting those engaged in homosexual behavior, whatever our views of that may be. This is also impacting people that have never engaged in that lifestyle or in that behavior. And now because, one judge says that the state failed to have a compelling interest in saving lives. Now no one gets the benefit of this drug that is so highly effective. And yet if they're in a different jurisdiction, then they might have the right to access this life-saving medication. So I think that this is a time when the federal government should step in to provide all people with some basic rights.
Bettina, you kind of alluded to it. When you start talking about substantial burden, how do we unpack that? How does anyone get to determine what a substantial burden really is?
Well, I think the judge in this case made the point that if someone asserts that they have a substantial religious burden or something is burdening their religion in a substantial way, then you must take that as at face value. Because, once a court starts to delve into, the whether in fact objectively that law or restriction is burdening your religion, then you're starting to get into entanglement with religion, which is, of course, a First Amendment violation. So, this is a really tricky area. And traditionally, courts have taken at face value the assertion of religious individuals who claim a burden on their faith.
Well, if the courts don't take it as face value, and Nia, I'm going to ask you this question, doesn't that put the courts in a position where they now have to basically go through a sincerity test of some sort, where a court now has to determine whether or not you as an individual, you as an entity are serious about your beliefs? And do we actually want courts actually making those decisions?
Well, I think it depends, right? Issues of sincerity have always brought a lot of controversy and, I think great scholarly conversation within the law, because it's really hard to, develop a metric for what it means to be devout. But I also think, and I know we've talked about this on some of the other programming, that, when you choose to enter the marketplace, you are then putting yourself at the mercy of the broader population. And so no one is asking, these individuals who may have very real and serious convictions, though, if you would like to be in that space, you could choose to stay within a straight religious context. I mean, part of the issue with Hobby Lobby is that Hobby Lobby is a craft store. It is a place where you go buy construction paper for your children and you buy scissors and you scrapbook and you do a number of different things. You chose to enter the market and become a widely lucrative space that hires a wide range of people. And so, yes, even though there are issues, of whether we want the government to be involved in sincerity, I think there also needs to be a bit of introspection on why are we so intent on entering the marketplace and not wanting to be regulated in the same way, especially when you have such a large and wide pull on the population that you're employing.
And that's a good point, Jennifer. When you look at somebody who wants to get into a space where you're going to have to be hiring probably large numbers of individuals of all walks of life, does it make sense that you try to put yourself in a position where you could have taken a lesser role, but you wanted a bigger role, probably because of the financial aspect of it, and now you want to pull back and we don't even get a chance to determine whether or not this is real or how we determine whether it's discrimination or not?
Yeah, I think that's the issue. This company is benefiting; they're making money, they're making profit, but yet the belief of the owner of the company is now impacting all of his their employees, and so it's kind of having your cake and eating it too, right? It's even though you might not believe what I believe, I'm going to impose my beliefs on you and still get the benefit of this business, and making money and reaching the broader public.
Well, when I think of what we've talked about with Hobby Lobby and even where we are with Braidwood Management, I think one of the directions we're going to find ourselves going to is determining that corporations are not going to be any different than people. But who actually is the corporation? Is it the person who's the chairman and the CEO? Is this something that actually could take place from a public corporation standpoint in which you have thousands of people that actually own the company and whoever's in a leadership position makes this decision? Bettina, this seems like this opens up Pandora's box in an unbelievable way in determining what aspect of this quote unquote entity do we actually protect a religious belief.
I know it is such a conundrum. I mean, and in this instance, I think part of the argument was that this was a closely held corporation, and that was weighed as making some difference in the equation. But of course, the fiction of a corporation being a person is not a new one. I mean, we use this in business law, and the corporations are treated as legal individuals or persons. So on an abstract level, it makes some kind of sense. I think in this instance, in when we're talking about fundamental human rights, I think there is a categorical difference in which the fiction actually muddies the water and destroys the very essence of the notion of religious freedom.
I have to let that be the last word, Bettina, but I think you hit it right on the nose where when you're talking about protection of fundamental rights, how we start muddying the water with individuals and corporations is something the courts are going to have to make a whole lot clearer. Nia, tell me something I don't know.
So something I think that you would not know, and maybe our audience would not know, is that, to finance the birthing of children and infants, you actually need money and some level of state involvement. Many people obtain prenatal care and postnatal care and infant and pediatric care through things like Medicaid expansion, through, expanded coverage benefits and what have you. And so it's important for us to remember that if we are moving into, what, regardless of your belief, a post-Dobbs space, then we need to be mindful of the other health policy infrastructure that we have in our states prepared to take care of people's children.
Wow. Vilo, tell me something I don't know.
Did you know that the June 19th celebration for people of color originated in my home state of Texas?
No, I did not know that. Bettina, tell me something I don't know.
So we always talk about religious freedom on this program, it seems, in the context of controversy. Maybe we should be heartened by a recent survey which found that 60% of Americans say that religion is very important to their identity and that it should be protected accordingly. So there is some level of unity on the issue of religious freedom in this country.
Wow, glad to hear that. Jennifer, tell me something I don't know.
Sure. Going back to our first segment, a recent study found that about 8 in 10 American adults say that there is some level of discrimination against transgender individuals in society, and they favor laws to protect transgender individuals from discrimination in jobs, housing, and public spaces.
Wow, that says a lot about our society. Well, listen, guys, I'd like to thank you for being part of our conversation today. We really talked about some great things, and hopefully we'll get a chance to expand upon it at another time. Thanks again for being here with us today. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.